Hi everyone, welcome back to another training session by Homula Realty. Today we're going to be talking about selling a tenanted property. A tenanted property can cause a lot of issues when you are deciding to list your property for sale, and we're going to talk about all the details and what to keep in mind when you're planning to talk to your tenant about selling your home. Now, please keep in mind that this is not a legal advice. If you have any issues, you should be reaching out to your lawyer, your paralegal, or your accountant and get the advice from the professional that's trained to give you this type of advice. This is simply for your information, and please feel free to put comments at the bottom of this video if you have any additional questions about what we discussed today. So starting with the first thing that you have to know is when you have a tenant in the property, your access is going to be very limited. Meaning that if the tenant still lives at the property, they're not really obligated to allow you to go into the property, and also you're going to have a tough time doing staging or do any pictures of the property or virtual tours of the property, because technically the tenant can ask you to remove their furniture from pictures even if they allow you to go in to take those pictures, which is a tedious task and it's very difficult to do. Therefore, having the tenant leave the property in advance allows you to do all of these tasks a lot easier, and also your showings are not going to have any complications. Because remember, when a realtor books a showing, they generally try to align it with several other showings that they have for the client. And if you refuse that showing, the chances are they're not going to rebook that property unless they're really, really interested in it. And this happened a lot of times to myself and other realtors, that we never had a chance to go back and see that property. And even though that property might have been the right property for the client, but because client is too busy and they can't go back, then the seller loses the opportunity of getting an offer on that property. So access is very important and it can be limited. Now, eviction also can be problematic, because keep in mind that you cannot ask a tenant to leave just because you're planning to sell your home. The only time that a tenant can be evicted from a property is when you actually have a firm offer from a buyer that is planning to use the property for their own personal use or for an immediate family member. So therefore, it's important to understand that you cannot give a notice to your tenant just because you're planning to sell your home. Now, the problem is, even if the tenant agrees to leave before you list the property or before the closing date, they can change their mind if they haven't signed the proper documentation. And if they decide to stay, keep in mind that in your agreement there's a clause that says, that guarantees basically the property to be evicted, and vacant possession is guaranteed. So if that's the case, what will happen is the buyer can sue you for damages because you're not going to be able to close the deal, and obviously it's going to affect you drastically. All of these have to be dealt with prior to accepting an offer on your property, because once you have accepted the offer and the tenant refuses to leave, now you're in a situation that is going to be very difficult to resolve. There are lawsuits in relation to this issue alone. If you guarantee vacant possession, the lawsuit can be for thousands, and in some cases in tens or hundreds of thousands of dollars, and that is a huge damage, and it's going to affect your bottom line. So once again, the only time that a tenant can legally be evicted from a home is when a buyer wants to move in or wants to use that property for the immediate family member. Now, that only gives you an opportunity to give them a notice. The notice has to be more than 60 days, meaning that if, for instance, the lease interval is monthly and they're paying their rent at the beginning of the month, if you sell your property on the 3rd of the month, you cannot give them a notice for less than 60 days. So obviously on the 3rd of the month, it's going to be 2 months and possibly about 28 days that you have to provide this notice. Okay, so it has to be 60 days prior to an interval of the payment of the rent, or basically whatever day that the lease has started, and if it's 1st of the month, it will be the 1st of the month. If it's 15th, then you would have to provide 60 days notice prior to 15th of the month. Now, a few other things that we need to talk about. You got to keep in mind that even though you provide a notice, it does not guarantee that the tenant is going to leave, because they always have an opportunity to challenge and ask the landlord and tenant board to look into it. And you got to prove that the new buyer is actually intending to move into the property. And the new buyer's job is to provide proof that they're going to be using the property. And if that does not happen, the tenant is able to sue the seller as well as the new buyer that's moving into the property. A few points that you have to pay attention to. When you provide a notice to the tenant, even though if the buyer indicates that they want to use the property for their own use, it does not guarantee that the tenant is going to leave after the 60 days notice. What do we mean by that? The tenant can indicate that they don't believe that the buyer is going to move into the property, and they can challenge and they can literally go back to the landlord and tenant board and request a proof that the buyer is going to move in. So obviously the buyer has to go and fill up some forms and indicate that they are actually moving into the new property that they purchased. Now, if the buyer decides not to move in or not to use it for their personal use, then the tenant is able to come back and sue the current seller and the new buyer of the property. Currently, the tenant can sue for up to $50,000 in damages, including a full amount of rent that they are currently paying. So you're going to be liable to pay 1 year of full rent to the tenant, and they can also sue you for additional damages. Keep in mind that also landlord and tenant board can fine you for not being honest about the whole process. So the damage can be in tens of thousands of dollars once again, and we have to be very careful about what we do. Now, as a seller, if the buyer is asking you to provide a notice to the tenant indicating that they want to move into the property, make sure you have it as a clause in the agreement of purchase and sale. And the clause literally says that the buyer acknowledges that they are going to be moving into the property, and you're not liable for any damages if this does not happen. If you need to include that clause, reach out to a professional real estate salesperson to help you with preparing that document. Now, another thing that you have to pay attention to is when you provide that notice, if there's a possibility for you to get the tenant to sign an additional form, the form guarantees the eviction of the property, and if the tenant does not move out, then you'll be able to basically evict them within just a few days. That form is Form N11, which is an agreement between the landlord and tenant to end the tenancy. So if you can talk to the tenant, if they say 60 days notice is fine and they're going to move out, you can ask them to sign Form N11 just to guarantee that there's not going to be any complications. Or if the tenant tells you that if you want to sell the property, they don't mind moving out, get them to sign that Form N11. All of these forms that we talk about are important to be filled out correctly. Because if you make any mistakes, And if you don't know the rules of how these forms have to be filled out, then when the time comes for the tenant to move out, they can challenge you, and the whole process starts from scratch. So it's important to fill out all the tenants' names on Form N11 and have every individual sign that form. So if you have a lease that has 3 names as tenants, all those 3 people have to sign the form. Now, the tenant is not obligated to sign Form N11. And this is just an agreement between the landlord and tenant. Another item that you have to pay attention to is when you ask the tenant to leave the property, you have to pay them 1 month's rent. And that's the law for the past couple of years, that you have to pay damages to the tenant because you are the one that's trying to terminate the tenancy. It doesn't matter what the reason is. At the end of the day, that 1 month rent has to be paid. Now, the issue that we have is that 1 month rent has to be paid prior to tenant leaving the premises. So the tenant can challenge you on the day that they're supposed to leave and try to stay at the property claiming that you have not paid them yet. Now, this is a problem because if you pay them and they don't leave, now you're in a dilemma. So you have to see how you can handle it. A lot of times the best solution is cash for keys, meaning that you're going to get the keys from the tenant and you will pay them the amount right there and then. If the tenant refuses to leave, another solution that we suggest is the same solution, cash for keys, but you just increase the amount of payment that you pay the tenant to leave. Now, this could be an additional month of rent if they agree to it, or if you can see what the difference would be for them to find another place, you can pay the difference for a year or so and get them to agree to leave. Another option is to find them another property that they can move into. But make sure you do all of this before you accept an offer. Because if you guarantee vacant possession, guess what? You are going to be in a situation where you're going to have to fight everyone involved, including the buyer, the tenant, and everybody else, the lawyer. So it is important to do things properly in order not to get yourself into that situation. All right. Now, if the buyer does not move out after the notice period, they can refuse also access to the property as well. That's another challenge that we have. So think about it, that if you have a tenant and they decide not to move out, if you have and you're having difficulty with them and you're fighting them, they can refuse to allow any inspectors or bank people to move in to the property and do their inspection. Now, this becomes a challenge for the buyer, and because again, in the contract you sign a document that says you're going to allow them access. Now the buyer is going to be able to cause additional issues for you. So again, our word of advice is have these talks and these issues prior to accepting an offer, and make sure that you do not accept an offer without having a plan in place. Now that you are familiar with all the challenges that we discussed regarding selling a property with a tenant, you have to make sure that you hire a professional realtor that has the expertise to help you with the process. Now, once again, the realtor is not going to provide you with legal advice. But since they're familiar with the process and they know what steps you can take to protect yourself, it will help you drastically to be able to do the necessary steps not to get into any issues or troubles. Okay, so once again, we're going to review the forms that you require. The form is to provide a notice to the tenant regarding personal use of the property, or if the new buyer is planning to move into the property. If you're filling this form, make sure that you have the tenant's acknowledgement in your agreement of purchase and sale, and you basically make sure that you protect yourself by saying that the tenant is going, the new buyer is going to be liable for any legal action by the tenant. And if you are planning to come to an agreement with the tenant, the form we discussed was Form N11. Form N11 is a mutual agreement, and if the tenant signs that form, you don't have anything to worry about it, because it generally takes just a few days for you to be able to evict the tenant. It's just getting the sheriff to become available and come with you to the property to be able to evict the tenant. Now, if they sign Form N11, give yourself those extra few days before the closing date. So don't have the date on the closing date in case there are any complications. Just give yourself a week or two prior to the closing date. That way, if there are any complications, you can deal with it and you can evict the tenant and you're not going to have any issues. If you have the Form N11 signed by the tenant, and the tenant leaves the property and leaves any personal items, you're not obligated to deal with that. You can just get rid of everything, throw it in the garbage, and then you can provide the vacant possession to the buyer. Now, it's important for you to understand your rights and obligations, and if you are planning to sell a tenanted property, please reach out to one of our real estate professionals here at Homila Realty. Will be more than happy to guide you and provide you with the necessary protection and make sure that the process is going to be smooth. Have a wonderful time and see you till next video.